Here comes another crazy gun safety bill out of California, SB2. I'm going to break it all down for you today. Hey everybody, attorney Andy Marcantel. I'm a partner at the Attorneys for Freedom Law Firm, and today I want to do kind of a more in-depth dive on this crazy SB2 bill in California. I want to talk about the bill. I want to kind of explain the ins and outs of it, why legislation like this is concerning and should be concerning to the 2A community, not only in California but nationwide. And also, we've been asked a lot of questions about, is this going to change coverage? Does this limit coverage in some way for the attorneys on retainer program? We're going to talk about that too. All right, so what is SB2? This is a new gun safety bill that was just signed into law by Governor Gavin Newsom. And the point of this bill is to severely limit the ability of people to carry firearms in certain places. It also makes it much more difficult in many scenarios to obtain a concealed carry permit to begin with. There's a number of different regulatory things that it does in terms of signage on businesses and traveling with firearms and applying for your permit. So let's jump right into it. First of all, it does a few things such as raise the permit age from 18 to 21. It doubles the amount of training hours that you need to get a concealed carry permit, and it makes it more difficult as well to renew it by giving you a few extra hoops to jump through. Now, the question might be at the onset here, well, what's the big deal? What's the problem with this? We want people to be trained, frankly. And that's a very valid point, is that people should be trained and competent with their firearms before concealed carry. I agree with all that, but the problem here should be obvious. This is a slippery slope, right? The Second Amendment doesn't say crap about training hour requirements and age restrictions and things like that. It's presumed that United States citizens, presumed that they're going to be competent, responsible gun owners, okay? So if we cede ground in such an area, okay, what's the next bill going to say? What are the next requirements going to be? Are the restrictions going to keep going up and up and up and up and up? Well, bottom line is it's unconstitutional, arguably, for that reason. And we're going to talk about that a little bit more when we get into the holding that just happened from the federal judge that has blocked this bill from going into effect in large part. Another thing that this does, remember, okay, here we go again, guys. United States Supreme Court just ruled on Bruin, and Bruin is great because Bruin says for the first time in our Second Amendment's history that the United States Supreme Court is now officially recognizing the right, not creating a right, recognizing the right that was already in place from the Second Amendment for citizens to carry firearms and use firearms for self-defense outside of the home. Hallelujah. Finally, after hundreds of years of jurisprudence, we get to what should have really been an obvious fact to begin with. But they left a little string hanging out, right? And this little string is what we've been dealing with in many kind of left-leaning, gun-grabby type jurisdictions. And that little string they left hanging out in the language of Bruin is that while we do recognize this right, we also recognize the right of individual states to limit firearms use and possession in what they called sensitive places, okay? What's a sensitive place? Well, there are some that are historically recognized, arguably anyway. There are some places that traditionally, you can say, have been sensitive places. But what have all of these jurisdictions been doing since the Bruin decision? They've been grabbing onto that language. And they've been saying, oh, okay, so we're allowed, our legislature is allowed to restrict gun use and possession in sensitive places. Let's just designate the whole state or the whole urban area a sensitive place. And that's how they've been attacking Second Amendment rights in various states, right? So that's exactly what SB2 is attempting to do. It's trying to add lots of places to create a laundry list of sensitive places where people can't carry their firearms. And as many pundits have pointed out correctly, by the way, with all the additions to the number of sensitive places that they're trying to add, it makes it virtually impossible if you live in a more urban area, like a city, for example, to drive from one end of the city to the other without illegally possessing your firearm in numerous sensitive places. So practically it's difficult, but once we even get past the constitutional issues here, practically this is going to be a very difficult law to enforce. Also, it's going to add additional restrictions on business owners. So it used to be the rule that as long as the business didn't post a sign that said you can't have a firearm in here, it was presumed that you could concealed carry into a business. Well, they kind of flipped the math on that, right? And they said SB2 requires people to specifically put up a "we are friendly to guns, we are friendly to concealed carry inside of our business." Otherwise, it is presumed that you're illegally carrying it into their business, and that business is now considered a sensitive place. If you haven't caught on yet, doing everything that they possibly can to make it more difficult to exercise your Second Amendment rights and carry a firearm. Now, there is some good news, some hopeful news here, and that is that a district judge, Judge Carney, just blocked in large part many of the provisions in SB2. Now, SB2 is scheduled to go into law on January 1st, 2024, and this judge just issued a very strong ruling saying, and I'm going to quote him here because I love the language, SB2's coverage is sweeping, repugnant to the Second Amendment, and openly defiant to the Supreme Court. Sure seems like that to me. SB2 turns nearly every public place in California into a, quote, sensitive place, effectively abolishing the Second Amendment rights of law-abiding and exceptionally qualified citizens to be armed and to defend themselves in public. I think he's right on with this, and he opines that it's very likely that certain provisions, if not all of SB2, are likely to be found unconstitutional. So, very important to know that this law is kind of in limbo in large part. Now, of course, the Attorney General of California immediately came out with a statement same day of this ruling saying that the AG's office is definitely planning to appeal this as high as they need to go. They love the bill. They definitely want it to pass in its totality, and so they plan on fighting it. But this is a good first step to bringing these issues to the forefront. I'm glad this judge did the right thing, and we'll have to keep a close eye on it. Mark and I are going to be watching this one very closely. We got a lot of people who are attorneys on retainer members in California who've been asking these types of questions, and we're going to keep a very close eye on this story as it develops, as it works its way through the appellate legal system, and we will be bringing you guys updates as things unfold. Perhaps the most dangerous thing about SB2 is that it allows people to be denied their access to a concealed carry permit for kind of vague reasons, right? So some of the language says, okay, if you're determined by the state to be a danger to yourself or others, they can deny you a concealed carry permit. Well, my first thought is, who decides? Who decides what's meant by dangerous and who is dangerous? What does it mean to be a danger to oneself? Same argument as before, right? When we start adding this qualifying language and allowing the government to have this type of a power, it's a slippery slope. It can quickly become the government just kind of subjectively deciding who they don't want to have a firearm, which in jurisdictions like this is pretty much everybody other than the police. Now, since we've talked about what SB2 is, what it prevents, and what the legal status of it is right now, we've been asked to explain what effect, if any, it's going to have on coverage for attorneys on retainer and also for insurance-backed companies. Well, let's start with the latter there. Insurance-backed companies, self-defense programs, in other words, the norm in the industry right now that rely on an insurance company to pay out claims, are going to be in big trouble if that member is in California. And the reason is because, remember, there are myriad of exclusions here. These companies can say, oh, well, if you were in a sensitive place, well, then we're not going to cover you. If you're a prohibited person, well, we're not going to cover you. And there's numerous other exclusions that we've talked about on this channel many, many times. So read your contract. But if you're part of one of these insurance-backed companies that excludes sensitive places or being a prohibited person, then how you should interpret this video if you live in California is that they're about to add a ton of different locations that they can immediately exclude coverage for, right? If you are in one of these myriad of sensitive places that they are adding with SB2, assuming that it moves forward, assuming that it goes into law, assuming that it's successfully appealed and this law goes into effect in whole or in part, you should just interpret this to mean there's about to be a laundry list of extra sensitive places that your insurance-backed self-defense program can immediately exclude you for. What you should also interpret this video to explain is that if you don't jump through all those hoops that I just described that SB2 is going to add, that makes you, that's right, a prohibited possessor, a prohibited person, the type of person that one of these insurance-backed companies can immediately exclude. So keep that in mind as well. Now, how is this going to change coverage, if at all, for AOR? Well, all of this is just to get to the point that I'm very proud of, which is that it will not change our coverage. Why? Because we're a criminal defense law firm. We're real attorneys. We're not an insurance company. We actually represent people who are charged with crimes and often who are actually guilty of crimes. So if you use your firearm in self-defense, even if you're in a sensitive place, even if you're a prohibited person, and many, many other factors too that other companies will exclude you for, such as domestic violence, regulatory violation, things of that nature, we say no problem with attorneys on retainer. You've heard us complain about this before. We think it's pretty lousy that all of these other companies will exclude you for these types of things. And the reason is because the type of crime that you're looking at, if you act in self-defense and you're accused of not properly acting in self-defense. So for example, let's say you discharge your firearm and the prosecutor disagrees that that was a valid use of self-defense. You could be charged with something like aggravated assault. Maybe the person dies and you're charged with some form of murder, manslaughter, some sort of a homicide charge. Well, that is a different charge entirely than the charge of you had your gun in the wrong place. That's a different crime. Those are two completely separate things. And we think it's pretty lousy that just because there's a completely irrelevant crime, frankly, to the question of whether or not you validly exercise self-defense, that these companies would just completely exclude you. And the reason actually might be a little more simple to explain. It might be simply that it's illegal to ensure illegal acts. So even if they like the shoot, even if they think that it's a valid shoot, the question then arises, can they even take the case if there's this extra charge of having the gun in a sensitive place, for example, tacked on? We think the answer is probably no there, which is why you've heard of some pretty high-profile exclusions that also contained other charges on the complaint or indictment. So bottom line is, this does not affect in any way what we will cover with attorneys on retainer. We will gladly take your case, even if you were in one of these sensitive places. We will cover you as long as you signed up before the self-defense incident occurred, as long as you're charged with a crime or anticipate that you're going to be charged with a crime as a result, and as long as we, as your criminal defense attorneys, can reasonably argue self-defense. That usually means we can at least get the jury instructions so that we can send it to the jury to let them decide. As long as those three things are in place, we're not going to exclude you for anything that SB2 can do to you. All right, guys, I hope that helped to clear up some things about SB2, but keep in mind, my legal analysis is going to be exactly the same for any piece of legislation that does this type of a thing across the country. If your crazy legislature is thinking about passing one of these really, really unfriendly to Second Amendment rights type safety bills, we got no problem with representing you as long as you acted in self-defense, even if you were a prohibited person, even if you had the gun in the wrong place, even if the gun had a regulatory violation, even if it involved domestic violence, even if you were intoxicated by alcohol or drugs at the time. We don't care. We are criminal defense attorneys, and we actually love defending these cases. Make sure to like and subscribe if you enjoyed the video. Share it with a friend. As usual, make sure to throw a comment down below because we love seeing your guys' comments. We love interacting with you guys. You guys are the reason why we have such a great program. We've been listening to you and incorporating your thoughts and suggestions into our program. We also love to debate these issues. If you think I got something wrong, throw it down in the comments and we answer all respectful civil comments. Can't wait to hear from you. Go and check out attorneysonretainer.us, attorneysforfreedom.com to learn a lot more about our law firm. And until next time, my friends, this has been Attorney Andy Marcantel. Peace.